Thank you, Navjot. Uh, it gives me an immense pleasure to welcome Honorable Mr. Justice K.G. Balakrishnan, who was the 37th Chief Justice of India. And it is very interesting to note that he was the first person to be the Chief Justice of India from Kerala state. No better person than Justice Balakrishnan could have been to give a motivational address to our law students. The reason being that his entire life sketch is full of inspiration. Justice Balakrishnan was born at Puduthurupi near Vakom, a capital of Travancore state. He had his schooling in Government High School Vakom, and what further inspiring is that he had to walk 5 kilometers every day to reach his government school. After his high school, he joined Maharaja College for his BSc course and then Government Law College for his LLB degree. He enrolled himself as an advocate in the year 1968 in Kerala Bar Council and began his practice in Munsif's Court, Vakom. Simultaneously, he completed his LLM course also in the year 1971. And as an advocate while practicing in the Vakom courts, he pleaded both criminal and civil cases in Ernakulam district. He was selected in Kerala Judicial Service as Munsif, but subsequently he thought of that he had to traverse a long journey if he wanted to reach at the top of the judiciary. So he resigned. Indeed, it would have been a very tough decision to resign from judicial service, particularly in those days, that is about 45, 46 years back, when even getting into the state judicial service was very difficult. But his lordship was destined to be the Chief Justice of India. Therefore, he mustered courage and took a bold decision and resigned from judicial service. He started his legal practice once again, but this time in Kerala High Court. He continued to earn name and fame in the High Court during his practice, and in the year 1985, he was elevated as a High Court judge in the Kerala High Court. In 1997, he, under deed and transfer policy, was transferred to Gujarat High Court and appointed as Chief Justice of that court. During his tenure as Chief Justice, he was also appointed as Governor of Gujarat State, and also he was member of the National Law University Gujarat Governing Council. He then was transferred to the Madras High Court as Chief Justice. And for the knowledge of our law students, I would like to mention that despite the change of the nomenclature of Madras to be as Chennai and that of the state to be as Tamil Nadu, the High Court of Madras still continues to retain its name as High Court of Judicature of Madras. So he was appointed as Chief Justice of Madras High Court, from where in 2000 he was elevated as as judge of the Supreme Court, and in 2007 he was appointed as Chief Justice of India. Indeed, it was a very interesting tenure from many angles, particularly the decisions he had delivered as Chief Justice of India in the Supreme Court. After his retirement, he was appointed as chairman of the National Human Rights Commission for a period of 5 years. And I would like to mention a few of his judgments which he delivered at different stages. He, in Supreme Court, tried to exempt the office of the Honorable CJI from the purview of the RTI Act and directed the Supreme Court Registry to file an appeal against the verdict of Delhi High Court, whereby Delhi High Court had decided that the entire Supreme Court, including the Chief Justice of India, would be within the purview of that act. His Lordship, Honorable Mr. Justice Balakrishnan, was in favor of the personal autonomy to be given to the rape victims. He said that the victim should be at liberty to marry or not to marry with the perpetrator of the crime, and also she should choose to give birth or not to a child conceived through forced crime. His Lordship directed the government to eliminate the pornography sites and the hate speech sites from the internet, and the government had to abide by it. While in Kerala High Court as a judge, he directed the Election Commission to debar from contesting the public parties in the elections who imposed, rather forced strikes on the public, causing them great sufferings. One of his very important pertained to the lunch to be distributed in the schools, and this really helped the poor children who came from far-flung areas in the vicinity of the schools and enjoyed the lunch every day. In Supreme Court, once he had to hear the cancellation petition to PIL, that is public interest litigation filed by two persons for cancellation of the bail of Lalu Prasad Yadav, the former chief minister of Patna, and his wife Rabri Devi, also the chief minister, who were facing trial in a DA case, that is disproportionate assets case. But his lordship followed Justice V.R. Krishna Iyer's dictum of law that bail not jail is the rule of law. His lordship also prohibited narco-analysis test during investigation, and it was considered to be a confession, forced confession rather, by a person who is facing an investigation. When his lordship was the chairman of the Human Rights Commission, he once visited Kasargod, a town in the Kerala state, and took suo motu cognizance on a complaint of local public that their human rights have been violated by the harmful spraying of pesticide indosulfan. His lordship was very kind-hearted when he directed the government to open a super specialty hospital for treatment of the victims. Friends, now I'll give in brief, because there is a shortage of time, a brief account of his lordship's family. His lordship is married to Nirmala ma'am, and the two are blessed with two daughters and a son. One of his brother officiated as an IAS officer, as district collector of Wayanad, a popular constituency these days. Once again, I accord a warm welcome to my Lord Honorable Mr. Justice K.G. Balakrishnan, and just to mention that once more I had this opportunity when his lordship was kind enough to visit our college in 2015. Thank you, sir.
Thank you so much, sir. I would also like to welcome Professor Dr. Ravikant Swami, Director DME, Professor Dr. N.K. Behel, Dean DME Law School, and Professor Dr. Bhavish Gupta, Head Academics, DME Law School. I also welcome all the participants. I am sure that you will all have an enriching experience and will gain valuable knowledge in today's session. Over to the chief guest. Sir, you may start with the session.
Dear students of Delhi Metropolitan Education at Noida, the director, my esteemed friend and colleague, and all the well-wishers, the students, members of the faculty, and friends. This is a very, very good experience in this web seminar period. Because we are not able to meet each other, but now I feel more and more seminars are coming. The students from Assam, students from Bangalore, students from Delhi, Rajasthan, they are all holding. So students are now active, extremely active in interacting each other on various topics, human rights topic, then privacy law. Last week there was a right to life and privacy law, the new development in the privacy decision which was rendered by the Supreme Court. So all these are taking place in the academic world. The students are really, I feel, more benefited. They are exposed to lot of discussions, the talk, everything, and their exchange of ideas are more prominent and nowadays, because they are technologically vibrant. The elders of they only make use of the mobile just to make a call, but the students make use of the iPad, the computer, the phone, everything to the best of their talents, and the technology is within their hands. So they are making use of it. And what is that the students of law, the legal members of the legal fraternity to do in this COVID period? I repeatedly requested my friend, what am I to talk about to the students in these days? So you talk about the judicial system, the law students, about the law. Of course, the law is dynamic. The constitution is dynamic. Constitutional law is dynamic. No COVID, no corona can prevent the growth of law. But there are problems in our judicial system. Judicial dispensation of justice, there is some problem in the way in which there is not exclusively for us, but throughout the world. That is a serious problem, because the lawyers are not able to reach the court and argue their case, and the people, that means the litigants are not able to get proper justice from the judges. They are not in a position to get real redressal of their grievances. So how to solve it is a riddle. It is not possible to give any solution for the time being. Even today morning, from the Madras High Court, lawyer called me. Then I asked how because Chennai is a little problematic regarding the COVID situation. So then he said the judges are on conference through these conference, but one or two important cases are taken and some discussions and decision is rendered. Whereas large 35-40 cases are being taken by the court and decision was rendered, and to the satisfaction of the parties, the lawyers are happy, the litigants are happy, and this is not in one court. There are about 20-25 division courts and division bench courts are there. So this should happen in there. It should have happened. This is what is happening in the Supreme Court also. This is the situation. So we should have the regular system at the earliest. Otherwise, it will cause serious damage, and the people, those who are deprived of the benefit of the judicial system, the justice system, they will resort to other methods, which is not very ideal. It may create problem. That is the only serious. But people are quiet because they know the consequences of this, the spread of this virus, and they have to keep quiet and to find a redressal mechanism. Our health system should be improved. People, no citizen, nobody shall die without getting proper treatment. That is the motto. But as regards law students, this is an ideal time to make use of the best of your time, because now you are not traveling, you are not going out. Almost in majority part of the India, the people are completely locked down, and most of the time they spent inside. This is a time for reading, and reading. One thing you have to do is that you should be selective in reading. No use in reading things which is mostly, there are nowadays so many things are printed and published in the name of legal publications and in other subjects also. So that you must be very, very selective in reading and choose the book of renowned authors. And you should concentrate on various subjects of your interest, and not only read, you take down notes on what you read. What is these great philosophers, legal philosophers have said about law? What is there are in the legal literature field, there are plenty of books, and now it is accessible. I'm told that even the Indian Law Institute, the library is accessible by computer. I access many of the books. I saw it, I heard it recently. And for you people, Noida is nearby. You can just, if it is permissible, just half an hour travel, you can come to the Indian Law Institute, the library. That is a very good library. You can make use of. And the books are also available, though slightly the prices may be slightly because of the conversion of the dollar-pound conversion. It may be slightly costly for you, the youngsters, to purchase books of it. But you can spend time. I am sure that your library also may have good library. Your college also may have a good library. And you make use of the library and read books, take down notes, and every student should be a sort of research-oriented approach to the various subjects, so that you will find sometimes you may feel, oh, what is this transfer property? Why should I read it? Or what is this res judicata in civil procedure? What is this order one rule in publication? Why should I study? In these cases, I am going to be a criminal lawyer, a constitutional law. Why should I study about the compensatory cost and all this? But as a lawyer, if you are on litigious side or on a non-litigious side, or any branch of, you must be able to give a proper guidance to the client. If they don't come to you to seek clarification on the Article 21 of the Constitution. They come to you to solve their regular, ordinary problems. Then you must be able to give a satisfactory answer. That is why it is said, great American judge who said that the main purpose of what is a group of students went to him and asked him, what is the what is the great purpose of the lawyer? What is the use of? Then he advised that your duty is to lead your clients to the channels of wisdom. Whatever you give, whatever advice you give, must be leading to give him wisdom, not to give any. So once you are able to understand the basic things about the constitutional law, criminal law, civil law, the penal code provisions, the important evidence act and all these, you may, some of you will become the judicial officers. If you become the judicial officers, you must, in the initial period, you must spend most of the time in reading and understanding, and every point which is argued in court shall not itself confined to the exchange between lawyer and the judge, or the exchange between the lawyers, but it should confine to your research. What is the role? What is the new development in this branch of law? What is it? It is, of course, we follow the common law practice. The common law, what is the development? How this is the, and you should also make a practice. Most of us writing in English, even all the judgments are written in English. So you should be conversed. This is a foreign language. You should also read the books. Only you get that style of writing judgments. Writing judgments is a very, very important aspect, part of a judicial officer, and he should be able to know the subject and give the proper decision on that subject after hearing parties. And so many other things are these, because some of you only become the judicial, the occupant judicial. Some of them will turn out to be the members of the corporate group. You'll be appointed in some international organizations. Then some of you may become professors or lecturers in the academic field. Some of you will become the appointed as a bank officers. So a lot of opportunities are there for the students. You did not feel anything worried about the fact that you joined the law. It's an opportunity which is since last 20-25 years. So the law subject is opened up, because the earlier also lawyers were taken, the respected, all our freedom fighters, Mahatma Gandhi, Dr. Rajendra Prasad, all were lawyers. But even then, the people were not coming forward to become lawyers. That is because the opportunity were confined to only few lawyers. So now the students have large number of students have joined the law. It is all because there is wonderful opportunity for the young lawyers who you are prepared to do hard work. You are prepared to read, work, and help your seniors. Of course, some may have good fortune to be they may have some mentors, but even if they don't have such a facility, first generation lawyers also come up like anything. The only thing, there is a dedication, sincerity of purpose, sincerity of learning. All these are required to become a very good lawyer, a member of the legal profession. Now even a large number of colleges there are dearth of good teachers in the legal field. So that is also opening. Quite one who wants to lead a quiet life can be a lecturer or a professor in an institute. Even in Noida, there are a large number of colleges. So that is also a good opening. But all this, you should pursue the studies and go for master's degree or PhD or MPhil and other further courses. This will help you to improve your career, and many of them, they are all to my knowledge, those who are having a spark in it, spark there to study and understand things, they have all become wonderful products, either in the academic field or in the legal field or in any other field they become. Somebody asked why there are out of so many American presidents, most of them are lawyers. Why they have the lawyers become the most, mostly they become the American president. Then they said the lawyers have got this analytical mind. They don't see things just plain. They analyze things, understand things, and then only they take something for themselves. So that that is what the answer which was given. The lawyers are the prominent products in society because they analyze and critically view anything which is any analysis required. What is that? How? Reasons and all inquiry. It is all entrusted to the lawyer. The people have got a problem, then they straight away go to the lawyer and present. Sometimes they may not any cause at all. Even if they don't any cause, they go to a lawyer and discuss many things to settle their family problems. Now the courts are burdened with heavy number of cases. Even in the matrimonial courts, large number of cases are pending in the courts. What is the solution for this? The large number of cases. Solution is we cannot suggest. One method is the alternative dispute resolution, the ADR. That is one method, and the other is the same pattern, arbitration. But arbitration and all can be resorted to only in high-stake commercial litigation. Otherwise, the ordinary cases there should be a mediation. Every court complex should have a mediation complex also. In the complex, there should be a mediation center also. And there should be experts for mediating the matter. And in all matters relating to the relatives, relating to whether it is whatever the dispute of that nature, and all matrimonial family related matters should first, after the written statement, the pleadings are filed, the first attempt of the judge should be to settle the matter through mediation. And every court complex area, there should be a team of mediators, trained mediators. And the other day I felt that the Bar Council should initiate some course for mediation, or some training should be given to at least some talented lawyers, so that they will be able to guide the people. Because mediation also is the people will be the both parties, whether even whether A or B, they may be fighting like Kilkenny cats between. If they are near related, the fight is more furious and serious. That is what my experience. So their fighting mood, fighting spirit is to be slightly lowered and watered down. They should discuss the matter in cool, calm atmosphere. They must say what is that A is likely to get, what is the B is likely to get, what is the real dispute, whether justice is with A or B. These are to be discussed and some solution which may not be fully satisfactory to both parties, but nevertheless, ultimately, finally, they should have a sort of final settlement. This practice is seriously going on, say, in many the courts in America. This sort of practice is being done. There are trained arbitrators, trained counsels who they render their help freely for these things. So after the COVID, the impact of COVID should generate an atmosphere for more friendly, more humane, more equanimity, and more equitable this system we should evolve, because we have lost so many working days. We have lost so many working hours which we could have used for the help of others, which of course we make use of these hours for improvement of our talents. It is, but as we are not interacting with others, it is not possible to have a remedy to help others directly meeting them. And so after this impact of the COVID is over, the court should, all the high courts should rise to the occasion and give proper directions to the various courts in India, so that the system should be, the clogged matters should be so slowly wiped out, and the parties should be able to get proper justice, and our time-old traditional justice system should provide, and they should be able to get the benefit. The lawyers, many of the lawyers who are now not going to the court, now they are not able to earn anything. Some of the young lawyers are in serious financial difficulties. That is also because of this court situation. The impact is not only court system, but the life and prestige of the legal profession also is affected by this COVID. So the impact of the COVID on law as a general subject, we not only judicial system, but the lawyers as a profession. So many, of course, the others are able to do their best, but it is all not good for it is not possible to get the help of all people. So with these words, I conclude. Thank you once again for inviting me to this function. Thank you. Thank you very much.
Thank you so much, sir. Sir, with your due permission, can we have few questions asked by the
Yes, few questions. I'll no problem.
Okay, sir. So there is a question from one of the student that apart from after doing law, apart from going for litigation or for judiciary, what other options are there for the student who has done obtained the LLB degree?
That is why I said student, apart from judicial officer, he can be the law teaching, he can be the legal officers in the banks, and large number of banks are there, cooperative societies are there. Then the corporate world also now require large number of legal talented youngsters. They can join the corporate field. Then, of course, first priority will be either joining a law firm or independent and litigious side that is going to the court and argue cases. Of course, as a first generation lawyer, there may be some difficulty, and so for girls also there may be some difficulty in the initial period, but comparatively, it is the profession is bright, and one need not be worried about he can make a living out of this profession.
Thank you, sir. There is one more question. That what is the significance of the master's LLM degree if a person is going for litigation? Is it, I mean, essential for a litigant to do LLM? I mean,
We jocularly said
of LLM.
we studied law in those days. It was 2 years course. I was a BL, first year law, and by the time we know about law, what is law, we pass BL. So we really study law when we go for LLM. Then we have if you go for LLM, we come to the vastness of the subject. There are a lot of reading, and you see the reading of law is it doesn't come to all people. So that talent comes when you join for the LLM. So if those who have got opportunity and to study law or go for LLM should always avail that opportunity. That is what I feel. So in those days there were only a few subjects: constitutional, mercantile law, and criminal law. Now there are so many subjects on international law. All the LLM courses are in various subjects. So now the field is open. So students should avail, those who can afford to avail should make use of that opportunity. That is what I feel.
A few questions, I mean, a few students are asking the tips to prepare for the judiciary. Any tips you can give us where, which will help us for the preparation of the judicial service exam?
Judicial service examination. Judicial service examination, but I feel judicial service examination you should prepare. At the same time, you should also attend the course. You get the things from the court, what is happening in the court, what is going on, the court, then the courts, regular courts have the starts. So you should go to court. At the same time, you should study, concentrate. That depends on the various states. The Delhi, nowadays, those who are in the Hindi belt, though he can write exam in Delhi, Rajasthan, Haryana, Punjab, Uttarakhand, all these, one can write. Also, Bihar is not permitting, I think, the to write exam from other states. But it depends on the questions. The questions are not very tough, but you should prepare. I cannot safely say what is to be the for CPC. You have to study from the first definition to what is a decree. Then after the order 21, the execution petition. After that, you have to study. So then you have to study criminal law. The evidence has some syllabus also. They have some follow certain syllabus. The Evidence Act, Criminal Procedure Code, CPC, then CRPC, then some the Transfer of Property Act, then some land acquisition and all. They are not keeping land Transfer of Property Act also is there. So, but the specific relief act. So that is also these Order 39 Rule 1 and 2. So these are all the study, make notes, appropriate decisions on the point. Also take a note. Then it's not a tough thing. If you are good at study, judicial service examiner, you should collect question papers of the previous examinations and you will get model questions. That model questions you can follow, and in that type, only the same type of, sometimes the questions are repeated, same type of questions are being asked. That is also, these are all some of the tips.
Thank you so much, sir. So with the due permission of Director General, sir, Dean, sir, HOA, sir, and Director, sir, can we move towards the vote of thanks? Okay, sir. So firstly, I would like to propose a hearty vote of thanks to the distinguished speaker, chief guest for today's session, Honorable Mr. Justice K.G. Balakrishnan. Thank you, sir, for sparing time out of your busy schedule and delivering a very productive and knowledgeable address. We are really enlightened with your knowledge and presence today. I would like to express a profound gratitude to our Director General, Justice Bhavar Singh sir, Director sir, HOA sir, and Dean sir for their moral support and constant guidance. And I mention my deepest sense of appreciation and would place on record my hearty thanks to my co-host, Ms. Bepriya Lahiri, Assistant Professor Law at DME, for the smooth conduct of the session. And also, I would like to say a big thanks to Mr. Kush Kalra for this session. And finally, most important, I would like to thank the wonderful audience who have actively participated in the webinar, the session, and made it a grand success. With these warm words and kind message, we come to the today's session. Thank you, everybody. Thank you so much for joining.